Well, good afternoon and welcome to this guest lecture in our PhD program of Law, Ethics and Economics for Sustainable Development. Today we have a very special guest, Professor Carlos Bernal Pulido. He is a judge at the Colombian Constitutional Court and he is professor of law at the Universidad Externado de Colombia. He is the author of several important books on the theory of fundamental rights, on the principle of proportionality, and more recently on constitutional change in Latin America. And today he will talk about a very fascinating topic, also a very controversial topic, the topic of transformative constitutionalism, in particular in the field of economic and social rights. So I'm very happy, I'm very pleased to have Professor Carlos Bernal here with us. I think this is a very precious occasion for our students to have such an important guest. And so please, the floor is yours.
Thank you so much, Antonia, for this invitation. It is a huge honor for me to be able to have this conversation to all the people that join this Zoom. I understand it's open to other people, but in particular to the P.h.D. in Milan, I'm really honored, and for me it's a privilege to be able to share these ideas that are more or less a work in progress that I'm doing. And let me start with saying, you know, the title of this talk, and I would like this to be a talk, and then feel free to jump in and interrupt whenever you want to say something. It's about the following ideas. You know, Colombia has a constitution that was enacted in the year 1991 in a time in which maybe we can describe it with the words or with the concept of sociologists that talk about anomie. That is to say, a situation in which the legal system is not able to cope with the problem of the society, and for that reason, the norms are not suitable to achieve their goals. At that time, there was this tremendous war against the drug dealers, the cartel, in particular the cartel of Medellin, plus the guerrilla. And one thing, two factors that always have fueled that war and that internal conflict in Colombia are poverty and inequality. Still, this society is really poor. Right now, we are undertaking this very difficult mission at the Constitutional Court, which is reviewing the constitutionality of the emergency decrees. And what we can read in the newspapers is really very sad. For instance, yesterday I found out that according to the Department of Statistics, in the last month, the actual consume concerning eggs, rice, and potato dropped dramatically. This means that there are many people in their houses without food, because those are basic goods. Rice, potato, and eggs are really basic. Then we are still experiencing that situation in which there is a large segment of the population that is in poverty, in conditions of poverty. And then the other thing is of course, inequality. There is a very small part of the population who owns the companies of the country and has a wonderful income. And then there is a large part of the population, millions of people that either they lack every kind of income. The official data for this season is 20% of unemployment, but this 20% of unemployment is on top of 10% that we never count, which is informal work. Then that is to say, we are on a rate of more or less 30% of unemployment, which is just terrible for a society. But then the Colombian Constitution was enacted in 1991, in the middle of that conflict, and we have these two factors, which are, in addition to the internal conflict, war and poverty, sorry, and inequality. And then under those conditions, the constitution was enacted with the hope that it could change the society. It was the first constitution in which we have the participation of every sector of the society. It was the first constitution in the history of Colombia in which there was not one party that won a war or a battle and then imposed the constitution to the other party. It was a participatory constitution, an inclusive constitution. When we were drafting the constitution, I was in my first year at the law school, and I participated in some of the working groups. Okay, then the constitution had three particular issues that are of relevance for this talk. The first one is that the constitution entrenched economic and social rights as enforceable rights. No, like for instance, we have in the Spanish constitution, that is to say, rights that should be enforced according to what the legislature says in the policies that become laws. But we have economic and social rights that are directly enforceable by judges and by all the officials in the country. Then a second issue that is very important is that the equality principle encompasses not only the formal equality, but also the material equality. And this means that the state has the obligation or the duty to try to do the best it can to achieve real equality. And one third change that is quite important in the constitution is not only the creation of a constitutional court for the first time in the history of Colombia, but also the entrenchment of a specific injunction that is called tutela, that every citizen is a kind of constitutional complaint, is a little bit, has the spirit, is not the same, but has the spirit of the German Verfassungsbeschwerde, the constitutional complaint. That is to say, is a mechanism that is specifically designed to protect the constitutional rights. And of course, if we connect those three issues, then we have that here every individual has individual standing to go to a judge and request specific protection of their economic and social rights, and also of the positive dimension of equality. Then if it is not only equality under the law, but also real equality. The state has to do something to achieve real equality. Okay, then I will stop for here and do a little bit of comparative law. Then more or less in the same time, we have this situation in other jurisdictions. For instance, in Brazil, the 1988 constitution was enacted with kind of the same spirit. And of course, in South Africa in 1996, after the formal end of the apartheid, then they enacted a constitution with more or less the same feature. That is to say, a constitution that entrenched economic and social rights in sections 26 and 27 of the constitution. It created a constitutional court, and there is a way in which the citizens, the individual cases can go up to the constitutional court. And also there is this idea that society must change towards equality. Then under those conditions, South African scholar Karl Clare, in a very famous speech, he claimed the South African constitution is a transformative constitution. It's a transformative constitution. And he explained that the whole purpose of the constitution was quite different. And this is a very important doctrinal fact. If we compare, for instance, the South African constitution to the US constitution, what we have in the US constitution, or in many of the European constitutions, is the idea of keeping more or less the status quo. The constitution is enacted with the purpose to maintain legal certainty for a long time. The constitution is entrenched with the purpose of creating legal stability, to guarantee rights, to put a structure of power that is in place for a long time, then we need to decide, we need to make fundamental decisions such as, do we like a monarchy or a republic? Do we like a presidential system or a parliamentary system, etc.? Then the idea is stability, is the constitution is enacted with the purpose to keep the status quo in place. Now, the South African constitution is quite different. The idea behind this concept of transformative constitutionalism is that the aim of the constitution is to change society, is not to keep the status quo, but to change society. Now, one question that is up for debate among the scholars that have been working on this idea of transformative constitutionalism is what it is that we want to transform, and what is the point of departure, and what is the aim, what is the point to which we would like to arrive, or what is the arrival destination of the constitution. And here we have many different ideas. For instance, Claire seemed in his speech, he seems to have a very broad idea of transformative constitutionalism that encompasses, for instance, the real instantiation of the rule of law. That's a possibility. Transformation into democracy, the entrenchment of democracy. But one thing that is common among the Global South scholars that have been working on this issue is that two core points are still economic and social rights and inequality. That one of the purposes of the constitution is to create an engine, as Gargarella would say, is to put together an engine that can change society in the sense that economic and social rights can be protected, and also the principle of equality in the material dimension can be achieved. Now, let me come back to Colombia. With that idea in mind, some scholars began to think as the Colombian constitution as a transformative constitution. And without having this concept articulated, I think this, from the very early jurisprudence of the Colombian Constitutional Court, that was one idea that the court had in the intentions. The judges, even from the very beginning, from the first judges, they have that idea in mind, that the intention of the constitution was to transform society. And we can see that in early judgments, for instance, in which they could have said, for instance, that economic and social rights were not directly enforceable. There is a clause in the Colombian Constitution, section 85, that says that certain articles of the Constitution are directly enforceable. And if we look at those articles, are just the liberties. But then the first Constitutional Court took a good approach and said, it's not only those rights, we have to encompass also the economic and social rights, the right to education, to health, to a minimum income, to all these economic and social rights. They are also directly enforceable. And another thing is that they are not only enforceable in the abstract constitutional review, but also in the concrete constitutional review that the court undertakes when it reviews the judgments of all judges in the country concerning the tutelas injunctions. Then from the outset, the Constitutional Court, the judges, they had in mind that the Colombian Constitution was a transformative constitution. Now, with that in mind, then we have two main problems, and I think those are the two key doctrinal problems concerning economic and social rights, and we have still this ongoing discussion. The first one is concerns the determination of the content of those rights. In other words, when I talk about the right to education in abstract, the question is, what claims do I have, what right claims, if I am allowed to use this Hoffelian terminology, what concrete claim rights do we have when I claim that I have a right to education? Do I have the right to go to university? Does this mean that the state has to guarantee a place in a university, either private or public, for everyone who would like to go to university, or just middle school? Does this include high school? When I talk about the right to health, for instance, are static surgeries encompassed? Do I have a constitutional right to have the state paid, or the health system, the public health system, pay for my aesthetic surgery? Then one open question is what is the content of those rights? And also there is a methodological question, which is how to determine that content of those rights. This is one discussion. And then the other big discussion is the following. Once I know what is the content, then who is the authority that is responsible to assure that the content is delivered? And what happens if the politicians and the government and the public administration actually refuse to deliver, or more simpler, they don't do anything at all? What happens if they don't deliver? Can the citizens go to the judge? And now is the point: what ought the judge to do? That is to say, it is a good idea for the judge just to order what is needed, to issue a hard remedy, or is better for the judges to use, as for instance, Rosalind Dixon has said, soft remedies or weak remedies? It's a better idea to use weak remedies or strong remedies, or a mix of both. Then we have this twofold conversation. The first one about the content, and then the second one about the remedies. Then let me go first and talk a little bit about the first issue, that is to say, the determination of the content, and then we will focus in the second issue. Concerning the first idea, the determination of the content, we have different approaches in the world. One approach that is, for instance, the South African approach of the first court, and we can see, for instance, this approach in Masivuko, or in the case Subramani of the South African Constitutional Court. We have the following approach. The Constitution, the sections 26 and 27, it says that the state has the duty to guarantee the deliverability of water, education, housing, etc., by means of policies that are not unreasonable. That is to say, the same Constitution used this idea that the standard should be the test of reasonableness. Then the Constitutional Court took that idea, that the standard, to put in place a review that reminds the old judgment of 1948 of the House of Lords in England, that is the Westbury case, in which for the first time the House of Lords articulated the reasonableness standard. Then the South African Constitutional Court says, look, it is for the government, it is for the politicians to determine the content of their rights. I am not going to do that task. It's not my task to spell out that content. They have the discretion to do that. What I have to check is whether that determination is reasonable or unreasonable in every case. This is the first approach that we have in the South African Constitutional Court. It has been changing across time. For instance, I am collaborating in a joint paper with Sandy Liebenberg, and then she wrote 8 years ago a wonderful book on reasonableness, in which she showed that the South African jurisprudence have been evolved from the first very weak reasonableness test or review to a more structured proportionality test under which the authorities have less discretion. But then that is the first approach of the South African jurisprudence. And for instance, we can see in ceremony that the South African Constitutional Court says that health policy in which it is written that patients that have kidney failure but they don't have the possibility to recover, they are not entitled under the right to health to receive dialysis. Why? Because the government can focus the dialysis procedure, which is very expensive, to the patients that have a real possibility to recover. And then the Constitutional Court says that is okay, that is fine, that is not unreasonable under the financial conditions and the limited resources of the health South African system. Then we have a second judgment, for instance, that is Masibuko, in which concerning a very poor neighborhood in Soweto, Firi, the Constitutional Court says it is okay for the Joburg water company to say that people can only have 25, everyone can only have 25 liters per day of free water, even if this is not enough to cover the needs of the families in this place. Why? Because of the financial constraints of the companies and other stuff. Then they say it is for the politicians to determine the content of the rights, and the constitutional review, the aims of the constitutional review is just to make sure that that determination is not unreasonable. Now, another very different approach is the Colombian approach. In the Colombian approach, from the early jurisprudence, the court has seen itself as a court that is empowered and has the duty to spell out the content of the rights, of the economic and social rights. And the way to this is by means of determining a minimum standard of protection, under which we have clarity that the content of the right is violated or is infringed. For instance, concerning the right of education, middle school, the end of middle school is the threshold. Then everyone can claim that a part of the right to education is the claimed right to have public education or private education until the end of the middle school. Now, concerning the right to health, there is a state program in which all the procedures and medicines or drugs are spelled out, and that program that is called the PBS, it has the determination of the right to health. Concerning, for instance, the income, the Constitutional Court has spelled out that, for instance, the minimum wage that the government agrees to with the unions every year, that is the minimum income from the workers and also from the pensioners. And for some programs, there are also the different minimums, and the Constitutional Court is the authority that has the power to spell out that content. Now, if there is discussion about what is the right approach. For instance, David Vilchitz, a good friend of mine, he has written extensively on the problems of the reasonableness approach. He says it is too weak. It is not an effective guarantee of economic and social rights. On the other hand, for instance, concerning the Colombian jurisprudence, there have been at least two issues. The idea of the minimum core is, I think, is a good idea because it brings clarity. Everyone knows what is at stake when we talk about content of economic and social rights. But there are at least two problems. One problem is whether under extreme financial situations, we can go below that threshold. And the other question is why the content of the right exhausts, or we cannot understand the reason why, when I talk about the right to education or the right to health, why the content of the right is exhausted in the minimum. The Constitution does not guarantee a minimum. guarantee a right, and that right, if we think about a transformative constitution, then it is better to think that the constitution empowers the people to have more than just the minimum, and this is not unreasonable if we think about, for instance, the possibilities of the state to pay beyond or more, above and beyond the minimum. And then the third thing, which is an epistemic problem, is how to determine the minimum, how judges ought to determine the minimum. Why 50 liters of water every day? For instance, there is a judgment of the year 2011 in which it was the first one in which the Colombian Constitutional Court said that the minimum content of the right to water was 50 liters of water per day. And it quoted some soft law, international soft law concerning that content of 50 liters. But then the problem is the following. Is that the right standard? Is that the right criterion? Is that enough? What about the quality of water? And there are many discussions, even in judgments, concerning the quality of water and how to determine that content. Then we have, this is more or less a picture, a very quick landscape of that first discussion. I have written on that discussion. I'm not going to go and focus on that part. I have written on that part a couple of papers. Some of them are published in English. For instance, one was published in a German volume in which we render tribute to the person who was my mentor in Germany, Robert Alexi. Was a book edited by Stanley Paulson and Martin Borowski, and I wrote a paper on the protection, on proportionality. I suggested a structure of proportionality as a methodological tool to determine the content of those rights. And I also have applied this methodology in a couple of my judgments here at the court that the revision chamber in which they approved, they liked this proportionality approach in at least two judgments. But the first idea came from that paper that I wrote and published in 2016. But now let me focus in the second one that I think it is quite interesting for the purpose of this PhD program, because I think it has to do with things about the relationship between law and economics and law and policy, which is the following. Once we know what is the content that the public administration, for instance, has to deliver when we talk about economic and social rights, or even private actors, once we know what they have to deliver, the question is whether the court ought to issue strong remedies or weak remedies. And I will follow here the terminology that I think was proposed for the first time, maybe by Tashnet in a book that everyone knows, and then Rose Dixon in a paper of the year 2007, and then she has been following up this topic in several papers. But the basic idea is just to contrast, on the one hand, a remedy in which the court is the one who determines the specific products and services that the public administration has to deliver to the citizen. And on the other hand, we have weak remedies in which, for instance, the court just set the goal, that is what the public administration has to achieve, but does not determine how the public administration has to achieve that goal. For instance, if I'm going to talk about a case right now that just to illustrate this point. We had a wonderful case, a beautiful case that had elicited a lot of criticism, good criticisms, I think, here in Colombia, because also this is quite experimental, and I have I'm learning from the feedback that I'm receiving concerning those experiments. I'm going to talk about this case. This case is about the following. It's a case in which several students of a middle school in a town in the south of Colombia in which there was internal conflict. They had a guarantee of the right to education according to the Constitution and the laws until the end of the middle school. That is the specific guarantee that is set here as a minimum to the delivery of the right to education. Now, those students, they talked to a kind of ombudsman that we have here in all the towns, and the ombudsman use a tutela injunction, a constitutional claim, requesting the department to build a high school for those students in that place. Now, there is a decree concerning building of schools here in Colombia, according to which it is necessary to have 22 students to be for the state to be able to open a high school. And in that particular case, there were only 10 students. Then one discussion that the case went to the lower judges, and then the case was selected for review at the Constitutional Court, and then I was the judge that was allocated this case. Then when I saw this case, then I saw there are two problems here. The first problem is determining whether, again, the right to education is only a right to a minimum, or where the students are right to claim that the content of the right to education goes beyond that minimum. And after using the proportionality test, I determined that under those conditions was not unreasonable for the students to aim to undertake high school, and then it was proportionate for the state to be able to do something for them in the sense of finding a possibility to open a class for them. Then I decided that the content, that in that specific case, the content of the right to education encompassed the content of the claimed right of those students to go to high school. Now, the second problem was, what was the specific remedy? And now what I faced here was this possibility of having a strong remedy and a weak remedy. One of my colleagues in the chamber who dissented in this case, she wanted to issue a strong order. That is to say, she suggested that we in the court, we had to order the department to put together the resources and to build a high school, or to hire the teachers, despite the fact that the decree said that we needed 22 students to open the high school. Now, she suggested that we use the exemption of unconstitutionality, which is very particular institutions that we have here, according to which if a judge or a public servant is to apply a law that is unconstitutional, then this person not only has the power, but also the duty to accept the application of that law, that is to say, not to apply the law and then to apply directly the Constitution. Then her point of view was the point of view of issuing a strong remedy, and to command the department to open the high school with only 10 students and not with 22 students. I think I didn't agree with that approach for the following reasons. The first one was because I don't think that that decree was unconstitutional. I don't think there is nothing concerning, no argument that can ground the claim that a decree that requires 22 students for opening a high school is unconstitutional. In contrast, we can say that that decree is very well grounded, for instance, in financial considerations, in sustainability of the educational system that requires to a wise use of the resources in public education. Then I didn't agree with that. And then the second thing is that I was operating under conditions of uncertainty, empirical uncertainty. Why? Because I didn't know whether the department had the resources enough to build that high school. And I didn't know exactly how much could it cost, whether there was a place to do that, whether there were teachers available. I was operating under those constraints. Then a hard remedy is, and this is an example of a strong remedy in the sense that is a specific order that the court can issue with the purpose of telling the public administration not only what to do, but how to do it. My colleague wanted for those students to be able to go to high school. I agree with that. But in addition, she wanted for us in the court to spell out the way in which that service could be delivered. And I refused to agree with that. Why? Because I wasn't sure that the way she suggested was the best, and I wasn't sure if the public administration had resources for that. This one point. Then let me go to the other possibility that is that we can find in the literature, which is the weak remedies. When we use weak remedies, according to what Ross Dixon suggests, what we need to do is just to set the goal, is just to say to the public administration, you need to guarantee to those students to go to high school, and that's it, and that's it. I think this idea of the weak remedies, it solves some problems. It certainly solves some problems. One problem that I haven't mentioned yet, it is the problem of the separation of powers and the rule of law. Of course, the judiciary has to collaborate with the executive, but there is a point in which the judges, we cannot overstep the boundaries of our powers, and we cannot exactly we cannot eliminate the discretion of the public administration, and the strategy of the weak remedies is aligned with that respect of the separation of powers. This is one good point about this idea of the weak remedies. And the other good idea of the weak remedies is the following, is that it solves the problem of the epistemic uncertainty of the judges. If we judges, we don't have enough information, we don't have economic educational background, we don't know exactly the resources, we don't know about engineering, we don't know about the putting in place educational policies. It is not for us just to invent, just to create, to make up remedies without thinking. We can make terrible mistakes, and I have examples of terrible mistakes that the constitutional jurisprudence in several countries have undertaken, has done because of that. Then the strategy of the weak remedies has the advantage that that is putting the technical decisions in the hands of the technical people, and also of the hands of the people who know what are the resources that are allocated. Now, of course, the strategy of the weak remedies has also disadvantages, and huge disadvantages. The first one is that maybe the public administration can procrastinate, can say, look, it is up to me to decide even when shall I deliver those things. Second thing is that the public administration could, within the space of discretion, not do the optimal, but a suboptimal, or even one thing that is unsuitable to protect the rights. And then at the end, it might lead to just a symbolic protection of the rights, and not to a real protection of the rights. Then we have those two possibilities, and you can pick your poison. As a judge, you can pick your poison. That is to say, you can use either the strong remedies and then try to solve the problem, but maybe create mistakes, or you can use the weak remedy and say, look, I'm safe as a judge. I don't make the technical decisions, but then empowering the public administration to decide everything, and then at the end not seeing the guarantee of the rights. We have that landscape. Then let me go and talk about complex cases involving many claimants, and then I will go back to the problem of the remedies. Now, this choice between strong remedies and weak remedies are not only relevant to individual cases, like the cases, the easy cases, is individual cases, for instance, cases in which a person is requesting a drug or a procedure, or a case in which those students are requesting access to tuition, or people requesting access to water. But we have also this choice when we talk about cases involving thousands of people. For instance, in Colombia, we have the technical name is structural cases, in which we have thousands of claimants, and also those cases are mostly about the protection of economic and social rights. Right now at the court, we still have three mega cases open that are structural cases. The first one is the case concerning inmates and the living conditions of inmates in the jails. The second case is about the right to health, that is, the structure of the right to health, and the delivery of drugs and services by the health system. And then the third case that we have is, of course, one is that it is very famous, is the case involving IDPs, that is to say, internally displaced people that is connected to the internal Colombian conflict. Then in those cases, the claims that we have, most of the claims that we have is that, for instance, the people in jails, they claim they don't have access to water, to sanitation, to education, to resocialization, to health services. In the case of the IDP, we have thousands of IDP claiming that they don't have access to housing, public utilities, etc., because they were displaced from the country town to the cities. And then in the case concerning the health system, we have people claiming that the health system is not enough to deliver what people actually need, regardless of their income. And then here, the Constitutional Court has issued structural remedies, that is to say, remedies that involve highly complex structures of collaboration between all the branches of powers, the Congress, the public administration, and then the judges. And then in those three mega cases, we have exactly the same. That is to say, we have this choice between strong remedies and then weak remedies. We can either say, for instance, as the court had said in some judgments at the end of the 90s, that the prisons, they have to be built with under those conditions. The materials that the government ought to use to build prisons are A, B, C. There must be this space between people. That, for instance, there is a rule according to which there cannot be more inmates going into a jail every week than the people that are going out of the jail every week. Those are strong remedies. But also we have kind of weak remedies in structural cases. For instance, we have in the IDP case, which is a wonderful judgment of the year 2004, the judgment O25 of the year 2004, TO25 of the year 2004, in the first judgment, because there are some follow-up decisions concerning that case, is that we have beautiful weak remedies in which the court empowered the politicians and the Congress and the public administration to determine the best way to protect those IDPs, and then the court says, and then we will see, we will follow up. In those three cases, the mega cases, structural cases, the Colombian Constitutional Court has used one strategy that is very well known, for instance, in Southeastern Asia, in India and Bangladesh, which is a supervisory jurisdiction. That is to say, that once the judgment is issued, after that, the authorities, they have a time to comply with the judgment, and then we maintain on the court the power to review from time to time whether the authorities have complied. And my assessment of that strategy is that it is a very good strategy, because we can check what it has been done. And concerning those three cases, I think there is a lack of information on what is actually achieved by those decisions, and the opinions of the authors are mixed. Some of them, they are optimistic, and they say, look, without those judgments, the situations of the health patients and the IDPs and the inmates would be worse. But other people, they say, look, this has been a terrible mistake. Those judgment has been a failure, just symbolic judgment, in the sense that the Constitutional Court has shown that it cares, but at the end, the situation remains the same. My general opinion is in the middle ground. I think that the best of those three cases, the one that is really successful has been the case concerning the health system. There is evidence of the success of that case. Then maybe the less successful is the case concerning jails, inmates. I am in the supervisory chamber of that case, and what the data we receive is just terrible. But anyway, this is a problem that goes beyond the powers of the court. Then just to finish, and then to open up for the discussion, because Antonia told me maybe to prepare 1 hour, and then we can discuss for a little bit those issues. I can say what I would like to claim is just the following. I would like to make two claims. The first one is that according to the case, we should decide on the remedies. That is to say, there is no general recipe for what remedies to use. There are cases in which there is strong justification to use a strong remedy. For instance, I had a case in which I discovered, it was a very weird case from an inmate that said that every Sunday, when he received the visit of his wife, there was no water in the prison, and for that reason, when they wanted to have sex, they didn't have water for sanitation or hydration. Then he claimed that the prison should deliver that water on Sundays. Then for me, it was weird to read that claim. Why? Because I think maybe there is more beyond that claim, and I made a very deep research into the situation. I ordered some evidence to be sent to the court, and what I discovered was that the director of the jail, he had an order in place just for the sake of saving money, according to which there could not be more than 8 hours of current water in that jail. And that jail is located in a place in which there is 35 degrees Celsius every day. Then the problem was just terrible. And of course, I issued a strong remedy commanding that director of the jail to put current water and without interruption every day of the week. And that's a case, for instance, in which the judge ought to use a strong remedy. Now, under conditions of uncertainty, for instance, the case of the students in that town in the south of Colombia, or another case that I had, a beautiful case that I had concerning a bridge that students had to cross for being able to access their school in one town near Venezuela, in which also the point was that the bridge was broken and the students had to use the bridge, but I didn't know if actually the town had the money to pay for the bridge, and also I didn't know what was, from the point of view of engineering, the best decision. namely whether to build another bridge there or in other places. Then, despite the fact that I try to compile all possible evidence, I was also under conditions of uncertainty. What I have used in those cases is just a third kind of remedy, which is a deliberative remedy, in which what I do is just request the authorities and the claimants and other people to put together, to sit together, and to put together a plan to determine to determine how they will deliver the services that are commanded by the Constitution. For instance, in the one case was the student had to go, had to go to a high school. In the other case was a build must be bridge, but I didn't know how. Then I requested the stakeholders to sit together and to put together a plan. I gave them strict deadlines. And what I found is that this way of used deliberative remedy actually empower the authorities and empower the communities to work together. These remedies catalyze the authorities and the community members to work together. And in both cases, the solution has been great. I have been in touch with the people, with the stakeholders in both cases. And in one case, the students were sent to boarding school in which they had the guarantee of food and also housing, and the municipality provides for them a bus that takes them on Mondays and brings them back on Fridays to their town, and they are all very happy about that solution. And then in the other case, the bridge was built very quickly. Also, this case was publicized by the journalists, and then under those conditions, also the politicians, they had the incentive to work quickly. Then in those two cases, that deliberative remedy was very good. I think it was suitable. What I'm not sure is whether this is a good remedy for every case. Maybe in some of the structural cases, we need to have more of deliberation. And this actually can help to avoid other problems. And I will finish with just one last issue. For instance, one thing that we have discovered here, there is a group in one of the public agencies, which is called the Procuraduría. It's like a kind of ombudsman. It's not the same, but it has, to some respects, some functions that it resembles the ombudsman. They have a working group in which they assess the effectiveness of the decision of the Constitutional Court. And one thing that it saddens me is that some of the decisions in which the court has used strong remedies, at the end, they remain as just symbolic judgments. That is to say, the judgments, the issues, and the remedies are so strong that the authorities, they cannot comply, and then after the reluctance to comply, nothing happens, and they are not rendered accountable for that. Then I'm not sure that the strategy is that the good strategy is always strong remedies. In certain cases, that is the only strategy. For instance, the case that I had concerning the water in the jail of that town in the north of the country, the Colombian country. But in other cases, what I have found in those experimental decisions is that those remedies are those deliberative remedies can engage the community, create incentives, and then deal with the problem of uncertainty. Okay, and then I stop here. I would like to hear from all of you. I have talked too much. Thank you so much for listening.
Thank you very much, Carlos, for this very fascinating and broad picture that combines both your very deep knowledge in the field of legal theory and constitutional law and your practice, your experience in dealing with concrete case. This is really fascinating to me. And so I would like to open the floor for questions. There are our PhD students, but also I see many other young scholars. So I'm really happy to have in the audience young scholars coming from all over the world, and our PhD students, of course. So please, there is, okay, so there is a question from Costanza Rizzetto. She's a PhD student here in Milan. So I would suggest to write in the chat if you have a question, and so I will call you. Please, Costanza.
Okay. Thank you, Professor Baraggia, and thank you, Professor Pulido, for being here and for giving us the opportunity to listen to your experience and to your presentation. I am a PhD student, graduated in international public law and researching on the topic of cultural rights and cultural heritage as a human right. And I have actually two questions I would like to raise. The first one is really with regard to the topic of my research project, because you mentioned that in the Colombian constitutions, there is the recognition of economic and social rights as directly enforceable. And I was thinking about the International Covenant of 1966, which includes also cultural rights within this definition. So I was wondering if there was something that encompasses also the cultural component of economic and social rights that could be directly enforceable in the Colombian constitution. And the other question would be more related to the temporary and current situation, and in particular with regard to the right to health and the COVID-19 emergency, because when we talk about the issue of the possibility to go under a certain threshold in extreme financial situation, as you mentioned, I was wondering if rather on the opposite side, such a sanitary emergency, for example, could maybe raise the need to implement higher standards. And for example, I would like to mention just these concrete examples. When you talk about a list of drugs and treatments that have to be necessarily provided to people, maybe including masks has not been a thing that in normal times have been considered. Rather, in this kind of emergency, we need to implement the list, and so to put a higher standard. So what would be the approach of the Constitutional Court when we don't, it's not about going under the threshold, but raising the level of the threshold? Thank you.
Thank you so much, Constanza. Those are wonderful questions. Let me go first and talk about the cultural rights. Indeed, the Colombian Constitution has entrenched cultural rights. We have more than 70 indigenous communities, and the Colombian Constitution not only acknowledges the autonomy of those communities, but also protects their rights according to the International Covenant and to other instruments. For instance, Colombia is one of the few countries, I think in the total we are 22 countries that have ratified the ILO 169 convention that, for instance, includes the rights to a prior consultation to the indigenous people when the government, for instance, and also private actors, they will undertake projects in their communities or close to their communities, projects that can have a direct impact in the communities. Then and indeed, maybe you can read the Spanish. If you're Italian, you can read the Spanish. There are some beautiful decisions of the court in which the court has protected those rights. For instance, I could send you if and Antonio can share with you my email, and I can send you some of those decisions, and you will see the way in which we combine first the protection of the rights, but also we link them to the economic and social rights. Why? Because some of those communities, they are really under conditions of poverty, lack of water, lack of food. Then in many decisions, we do a package and we protect all of them. We protect all of them. Now, I have to say that on the other hand, on the other hand, this is one picture. But then on the other hand, we also had a different problem, a different approach that is has been very hard to solve. Is that in some of those places in which those communities they live, Colombia has natural resources, and also a big part of the Colombian economy depends on the use of those natural resources. Then a very difficult situation for the court has been how to reconcile, how to balance, on the one hand, the necessity of the state to develop and to use those natural resources, mostly by licensing international companies to exploit those resources, and also, and that on the one hand, and on the other hand, to protect and preserve the cultural rights plus the environment. And those are very complex issues. Why? Because in some cases, the indigenous people, they know better how to protect the environment. Then the point is, if we allowed for a limitation of the rights of the communities, then we are also taking from them the possibility to protect the environment in a traditional way. But also the problem is that this creates these incentives for the investors to invest in those projects, and actually the economy needs those funds for being able to pay the public educational system, the schools, the hospitals. Then it's a very hard balance. I can send you some decisions concerning that. Now, concerning the emergency, I won't say anything concerning the emergency, because I still have to vote in concerning those decisions, and some of the decisions involved, for instance, I am drafting the decision in one that is very controversial, is that by means of a decree, the government cuts 20% of our salaries, of the salary of some of the employees of the state, of the people who earn the most in the state. Then one allegation is that this is unconstitutional, because the salary is a social right, and then there cannot be regression in the protection of social rights. Then I won't say anything about that. But what I will say is that I agree with you, and I have written about this. This is a discussion that I have with a good friend and colleague, David Landau at the Florida State University. He believes that the content of a social and economic rights reduces to the minimum core, and only the courts ought to protect only the minimum core. I don't agree with that. I agree with you that prima facie, the content that is to be protected by the courts ought to go beyond the minimum core. And for that reason, what is relevant is the use of proportionality. When you think about using proportionality, the idea is whether what you aspire to have as a content of the right, for instance, the right to health, in the sense that, look, if normally we don't need all these drugs, but in the pandemic, under those conditions, we need all of that covered by the public system, the public health system, for instance, masks, blah, 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 protection for the doctors. This is not normal part of the right, but under those conditions, it is reasonable for me to claim that. Now, the proportionality tests that judges ought to undertake is whether this is justified. That is to say, whether, according to the financial conditions of the state, the risks involved, then if we balance, what you get. And in the decisions that we have to make now, we are undertaking those balancing exercises, which are very complex. That would be my answer for you. Second point, but I also, when you write to me, I will write it back to you and send you my papers on proportionality.
Thank you. Thank you. Thank you. So kind of you.
So do we have other questions?
Hi, I had a quick question for the judge.
Yes, please go ahead.
Hi, Carlos. Thank you so much for this very interesting presentation. I was just wondering if I could draw you back to your recent debate on transformative constitutionalism and the primacy of the legislative and executive process in taking the lead. So I'm wondering, in a lot of your decisions which you refer to, you said that there are epistemic problems. So some of these epistemic problems can be solved by way of, say, simply asking the government for more information, for asking them to provide details as to how their obligations to expend the maximum amount of resources available can be met. So I'm wondering whether some of these epistemic concerns can be addressed by the use of adding more parties who can give you expert information in order to parse the information into judicially manageable terms. And I'm wondering your emphasis on the legislative branches as the primary focus of the project of transformative constitutionalism. Is that born out of a place of institutional fit or something else? And the second question is, I was just wondering, when you were saying that the decision as regards remedies in social rights litigation is heavily context dependent, how do we avoid what we now know as remedial discretion, and how do we avoid situations where litigants have no prima facie idea of how their litigation is going to turn out? Just to give you an example of, say, how remedial discretion operated in South Africa. So we have very invasive remedies being given by very recently in 2018 and 19 by the Constitutional Court, which may be influenced by the fact that we have a weakening ANC. We have a society that doesn't seem to believe in the Constitution anymore. So I'm just wondering, how do we, you as a judge, how would you balance these kind of roles? Thank you.
Oh, thank you so much. Those are very complex questions. I think the pandemic will end before we have an answer for those questions. But I will say just a couple of things about both. Concerning the first one, I do believe that judges, we have the obligation to gain and to search and to gain all the information, to compile all the technical information for the cases. And in principle, we are the ones that are called to make those decisions. For instance, in many of my judgments, I do an exhaustive work of requesting evidence to have all this information, and also have people in my chambers. We have big chambers of 20 well-paid clerks and professionals, also with education in economics, in political science. And we do our best to have those, to understand that information and to make decisions accordingly. However, there are cases in which, even if you do that, there are conditions of uncertainty. I remember when I was studying in Germany under Robert Alexi in Kiel, one of my colleagues there, Marius Rabe, wrote a wonderful book that is called Fundamental Rights and Erkenntnis, is the Grundrechte und Erkenntnis. Erkenntnis is like possibility to know. Constitutional rights and cognition would be like the title of this book. And one of the issues that is dealt with deeply in that book is that problem, that there are cases in which, even if we have all the possible information that we can find, we are operating in conditions of uncertainty. And there is one thing that I do believe is key in every constitutional democracy, and is the following: is uncertainty is solved by means of political legitimacy. That is to say, when we operate under conditions of uncertainty, in those scenarios, is where we need to make a call to political legitimacy. We need for the politicians and the technicians to talk about that. that's the place for the public authorities to undertake political control of the decisions. And for that reasons, in those situations, I think the call to make the final decisions concern the political authorities. But that's also my technical, my view. And I haven't written about this issue, but I have several examples in which courts have made terrible mistakes because they haven't deferred to the political authorities when we talk under conditions of uncertainty. Now, concerning the second problem, I know what you mean is that maybe there are you know, if what I say, if what I claim is that the choice of remedies is context dependent, then I can create two problems. The first one is too much discretion for the judges. That is one problem. And the second problem is a problem of inequality, which is, for instance, the following. If, for instance, let's say my colleague that was not in agreement with me concerning the right to education case, she is the chair of a chamber number 2 of review at the Constitutional Court. And let's say I am the chair of chamber number 1. Then in chamber number 1, we decide those cases with deliberative remedies. In chamber number 2, the 3 judges that belong to the chamber, they decide cases with a strong remedies. And we have a problem of equality and also consistency. Now, my answer to those problems is the following. To the first one is that judges always, we have discretion, but the point concerning theories of judicial argumentation is that at the end, there must be a justification for the remedies. That is to say, is not just that I make those decisions whimsically, but I have to make the decision to choose a remedy and then build a justification for that case in which I try to make the best argument. And of course we can disagree, but the justification is a limit for the judicial discretion. Now, concerning the second problem, that is to say the problem of inequality and inconsistency. Now, the point is that over time, there tend to be unification. When, for instance, that's one beautiful conversation that I also had with my friend David Landau. When we talk about this, the minimum core of the rights, sometimes it takes time. It takes time for the courts to deliver that minimum or to agree upon that minimum. Then my experience is that over time, there can be unification and they can solve this problem of inequality and also the problem of lack of consistency or coherence. I don't know if with this I answered your questions.
Thank you.
So we have a question by Mariam, please.
Thank you for the presentation, and it's especially interesting for me because I just finished my chapter on health rights jurisprudence in Colombia, and so I will use this great opportunity and ask you several questions that remain uncertain for me still in the Colombian context. So my first question is that you also said that the health case was quite successful. The health case was one of the most successful in that among those cases, structural cases, but still there is an upward trend in terms of tutela actions. So my question is, some explanations are that, for instance, there are new claims such as for caregivers and other expansion of claims, but in the face of the law, which included all the services, and unless it was excluded directly, why is that so? Why is this trend so high still? Is it because the system remains dysfunctional and the judgment was not that successful, or it's just because there are more claims because the healthcare plans were expanded? And the second question is about corruption charges against the healthcare providers, whether this has really transformed how these providers operate, or it was just ad hoc answerability of specific healthcare providers, and then system continued to function mostly in the same way. And a just general question, which is my last thing that I'm thinking about the Colombian chapter, is the court asked for participation, and if we understand that in a social rights context, participation is particularly important, and for instance, in South African context, meaningful engagement can be seen as something really progressive. But my question is that in a situation where there are power imbalances in the system, for instance, in the healthcare system, and for instance, also how difficult it is to have fundamental reforms in healthcare, at least it was very difficult before the decision. So what is the value of participation? Because when we're talking about eviction, we're talking about people who are directly and differently affected, right? Because they are the ones who will be evicted, and the state agencies can get different kind of information from those people. And it's a limited number of people. You can understand how you can manage the participation process. But when you're talking about healthcare system and everybody is affected, and it's really difficult to differentiate what kind of different effects people have, what is the value of participation, and what can courts say more how the state will go about it? Sorry for these many questions.
Thank you so much, Mariam. Look, what I wanted to say is the following. I think your questions address one of the most difficult points concerning social rights litigation, which is very sad to say. And it is the following, is that many of the social rights litigation problems are too big for a court to be able to solve them. That is to say, no matter what happens at the Constitutional Court, maybe in the foreseeable future, Colombia would never have a health system like the one that is in place in Norway or Australia. No way. Why is that? Because you know the main factor of those systems is money, and you cannot make money by means of judgments. You cannot enhance the budget. You cannot enhance the internal product of a country just by means of judgments. You can wish you have more money, but there is no way judges can fabricate. Indeed, we are just the country. We take money from the state. We don't create wealth. We take wealth from the state, judges and lawyers in general. Then it is very sad to say that one problem like the health problem cannot be solved by one decision or by many decisions of a court, because the problem that is at the heart of that is lack of money. It's lack of money. The same, for instance, about education. Before I was appointed to the court here in Colombia, I was working at one of the biggest universities in Sydney, Australia, and I can tell you the following: just the budget that university had for P.h.D. scholarships is bigger than the budget of the two biggest universities of Colombia. Then it's not a way in which you can make those comparisons between very well developed systems of health and education, etc. I think that explains my answer to your second question. That is to say, why do we still have litigation? Because the system is not able to deliver everything that is requested from the system. Now, despite many things, for instance, despite the fact that tutela judges they have, and also the Constitutional Court, they have acknowledged that people have rights to drugs and procedures way beyond the basic program, that the basic program has improved, all of that. But beyond that, people have needs that go beyond what the state can guarantee, And in a situation like this, in which you additionally have the possibility to go to use that injunction without any lawyer going to every judge, and that's just with a piece of paper, claim what you want, then for that reason you have that increased litigation. Now, let me go back to the first point, is that why do I think this is a successful case? Look, under those conditions, the conditions of Colombia as a poor country, I have been do you live in Italy? Mariam, do you live in Italy?
No. I study in Budapest, but I live in Georgia now.
In Georgia, okay. But look, I have been in a hospital in Italy once with one of my daughters who had a small problem. Even if you go to a we went to a hospital in the southern Italy. It was Christmas, and they gave us even gifts for our daughters. You can never experience something like that, and the hospital was not luxurious, but you can never experience something like that in a country like Colombia. Now, the point is the following, and even under those conditions, if you compare all the indicators right now to the indicators that we have 20 years ago, you can see a big difference. And the health judgment of the year 2008 is a wonderful judgment because of the following. It had weak remedies that then elicited a public debate that went up to the Congress, and the Congress made a law, which is the statutory law of health, following the guidelines of the Constitutional Court. And that law radically changed the health system for most of the population. For instance, that law complied with one of the orders of the court, which was just to create a system that was equal for everyone. Before that, we have two-track system. One system that delivers some good service or medium good service for people who could pay, and then one terrible service for the people who weren't able to pay. Right now we have one only system, and even if you do that, is terrible, but it's terrible for everyone. That is to say, we have the basics, and then if you compare the data, you can see that there is progress. Now, let me go to your final point. I think there's still corruption, a lot of corruption, but this also goes beyond the powers of the court. This is a cultural problem. There are institutions in place. Right now, what I have seen during this time of the COVID-19 is that the three main institutions that fight against corruption, the Attorney General, it's called Accounting Office, the Contraloría, and then this kind of ombudsman, the Procurador, they put together efforts to try to put limits to corruptions or to fight against corruptions, and then they are doing it. But there is still corruption, I think, in the health system. And of course, if you have a system that is not wealthy, and in addition you have people taking illegal money from the system, then the result is not good. But now my final remark is that you are touching one of the deepest issues concerning economic and social rights, is that you can have the most beautiful, the most appropriate social rights jurisprudence. But the problem is that at the end it depends on money, and you cannot create money by means of law. That would be my answer.
Thank you.
Thank you very much. And so I think we have time just for the last question by Yashim, please.
Professor Baraji, and thank you, Judge Bernal, for your I am a student of constitutional law, but I have been benefited from your insights, socioeconomic rights, implementation of socioeconomic rights. My question is very quick. How, since you devised the remedies in weak remedies, strong remedies, and deliberative remedies,
I cannot hear you very well. I think it's
oh, yeah.
I wonder if you turn off the video. maybe you can turn off the video, and then it would be maybe
Okay.
better. And also, I will turn it off. So maybe if you can try it right now.
He's having problem with the speaker.
Yes.
Maybe you can type out his question on the chat.
Maybe you can type. I see one question that is is written here about the proportionality.
Yes.
To that person. You maybe I can send you, Antonia, my paper on proportionality, and you can pass it to this person that is asking about that.
Sure. I think if Jashim can. Okay. Yeah.
How do constitutional court deal with non-cooperative governments? Oh, that's a real tricky question. That's a real tricky question. Look, I think it's a question that is relevant everywhere. 2 years ago, I was in London at the King's College in a summit, and I had the possibility to talk there with Susanne Bae, which is a colleague from the German Constitutional Court, and they were dealing with a very difficult case that involved the participation of extreme party rights, of extreme parties in political issues in towns. And she told me that they issue an order for a mayor of a town to allow the representative of extreme political party to go into the town hall, and the mayor refused. Then I asked, and then what did you do? And then she said, we are powerless. We just wrote a letter, and the letter was published in a newspaper. Then that was the only mechanism that they had for making this measure to comply with the order. Fortunately, at the Constitutional Court here in Colombia, we have a very effective remedy, is that we can send people to jail. That is to say, if we issue an order, let's imagine that director of the prison to which I issue the order to open the water tap without interruption. Then what we did with that case is that we issued the order and he complied. Why? Because if he refuses to comply, we can put that person in jail. Now, those are things concerning individual cases. But now the biggest problem is what happens, for instance, if we have a structural case and we have a government that refuses to cooperate. Now, that is trickier. That is trickier. Why? Because that would need involvement of the public audience and also the Congress. We have never been in Colombia in a situation like that. I think the majority of the cases, we have never had a president saying we don't comply with the court. Mostly what we have is that they don't do anything. In those cases, I think this idea of the supervisor jurisdiction is a good idea, and we can follow up and we make public hearings, and then those people have the ministers, they have to come to a public hearing, they have to say what they have done for complying with the decision, and this has helped. This has helped in general.
Okay. So thank you very much. I think our time is up. I want to thank Professor Bernal for his precious time, for having accepted to be with us today. And I really hope that there will be the chance to have you, Professor Bernal, in Milan, at the University of Milan. I think that Professor Bernal is one of the most brilliant minds in comparative constitutional law, and we are really privileged to have him today with us. Just a final remarks. which is about a call for papers for young scholars issued by the Young and Comparativist Committee of the American Society of Comparative Law. Since I see in the audience many young scholars, I invite you to check on the website of the American Society of Comparative Law this call for paper. It will be an online seminar in October. It was supposed to be in Boston in person, but we cannot do this anymore, so at least until now. So there will be a webinar about comparative law for younger scholars. So you are all invited to submit your application. So thank you very much.
Hi, Antonia, can I just ask you a question about what's the format of this going to be like? Is it going to be discussion? Will we have to submit papers in advance? Will it have a chair?
Yes.
Do you know what the exact format is going to be like?
Yes, you have to submit a paper in advance, and there will be a discussion about your paper. Yes, there will be parallel panels within the main conference of the American Society of Comparative Law. Yes, write to me if you need.
Thank you.
Okay.
Yeah, thanks very much.
Thank you, everyone, and have a good day or have a good evening, depending on the time zone. Thank you, Carlos, again.
Thank you so much. Grazie mille, Antonia. Spero di poter visitarti a Milano.
You are always welcome. Thank you.
Grazie mille. Buon fine di settimana.
Grazie mille, grazie mille.
Grazie.
Thank you.
Grazie, arrivederci.
Arrivederci.
Arrivederci.